Okay. All right. Let's just. This is a really intense area. You know, there's a lot. You know, it's very hard to go through 92,000 pages and say, well, these pages are relevant, these ones aren't. But I've tried to do that. I've tried to just go through and just pull out those things that I think are relevant. So we might just go through them. I'm not going to go in great detail on these slides. I'm just going to introduce you to the topic and maybe just have a quick talk about what it's about. One of the first things that we do as very clever startup people is we say, I know, staff come with all these three bags for, you know, they've got PAYG, we've got superannuation, we've got workers' compensation, we've got, you know, we've got to pay them all this stuff. It's all very too hard. I tell you what I'll do, we'll be very, very clever and we'll employ them as contractors. There you go, we're around. We've solved all the problems. Well, the government's onto you. You know, the government has figured out there was scammers in the system long before you guys came along. And so what the government tends to do, particularly in two areas, in tax and in workers' compensation, the government has this deemed thing, D-E-E-M-E-D, deemed. So whatever you want to call it, and whatever agreement you've got written, they will deem someone an employee even if you treat them like a contractor. And there's certain things that they go looking for to say, yes, they're a genuine contractor or not. So it's all very well to say, I'm going to keep them as a contractor, which makes an awful lot of sense, but the government may well turn around and do it. And this happened when I was in Darcy's story. I always got to remember Darcy's stories. This happened when I was in the plastering business. This is what happened, right? Employee was employed as a contractor. That's what they did. So what do you do with a contractor? You say, I'm going to pay you the full amount of money and you look after your own tax. Makes an awful lot of sense, doesn't it? So the guy goes, yeah, fair enough, whatever. Yeah, no problem. So he gets this money, see? Anyway, he ended up getting sacked or retrenched or wasn't used again. Anyway, when he puts his tax return into the government, he says, this is what I got net from that organisation. The money of my tax would be paid by the organisation, because this is my net and the PAYG is belonging from the organisation. So the government came along, they checked it out and they said, yes, he was an employee. And the organisation had to pay the PAYG tax. Even though their arrangement was as a contractor, the government said, no, he's an employee. Under tax, you, employer, owe us the PAYG, which you should have been withdrawing from him all that time, you see. And he says, no, the money they paid me was my net, they must have the tax. And that's what happened. So we've got to be careful that if you go this route with a contractor, that it is a genuine contractor and that it doesn't get undone by either the tax office or probably the most strict is workers' compensation. Workers' compensation will just come in and say, I don't care what you call that bloke, he was a worker, you should have covered him. So you've got to make sure that that's and so what I've got there, I've got there's two forms, employee of and contractor for. And that's really the test that they look through. They look through to say, okay, if they are an employee will be paid by the hour and receive benefits, whereas a contractor is paid for results and is a non-worker. Materials are supplied for an employee, and it's mostly labour charges only, whereas a contractor will provide their own materials, their own equipment, and they will not have invoices that are coming in labour only. It'll be labour only plus supplies, you know, makes sense, doesn't it? So just go through that list and you'll see that if you are going to employ someone and say they're a contractor, make sure you're ticking off the right-hand column there. If you're not ticking off the right-hand column, basically if you're ticking off the left-hand column, then basically whatever you call it, whatever deal you've done, they're going to be an employee. So think about that when you go to put that together. Under the Workers' Compensation Act, the Workers' Compensation look at three things. But first thing they do is that directors aren't covered under the Act. So under Workers' Compensation, if you've got a proprietary limited company and you're a director, you can't get workers' compensation for yourself. Directors can't say, oh, I'll get workers' compensation. So if you're operating as a company, you have no workers' compensation because workers' compensation doesn't cover directors. It only covers workers people that work for that company. So you need to go and get private income protection or something like that to cover you in the case of lost hours due to work accidents or whatever. In terms of this is that deemed thing. When someone makes a claim and say, I worked for them, they tried to treat me as a contractor, but I did work for them, they will look at those three things. They will look at were they paid to achieve a specific outcome? In other words, there should be a job order in front of them that says you've got to repair that light. It shouldn't be you turn up for work for 5 hours and we pay you so much an hour. It shouldn't say that. Secondly, they should have been providing their own plant and equipment or tools of trade. And finally, if something's gone wrong, then that contractor would be liable. An employee wouldn't be liable for making good. If they've repaired that and it hasn't been prepared properly, you have to come back and fix it up. So it's a little bit of a test, and what I tended to do, because I was in the contracting business, and they were genuine contractors, but I used to sort of include this clause on everything, just to make sure I ticked the boxes. So whenever I was sending money out or whenever I was engaging with people, I would say this, this payment is made in relation to, and you wouldn't say your hours of work, we'll say in terms of your repair or your plastering of the ceiling in 104 Koala Street or wherever, as detailed in your quoted schedule of work that requires you to provide your own plant and equipment. Note, you are liable for the costs of rectifying any defects in the work you perform. So if you've got that going out on all of your invoices, then it is actually continuing to reiterate the fact that the person is a contractor, and they fulfill those three basic things that separate a contractor from an employee. So just be a bit careful there, that's all. It's all very well to say, I'm just going to do contractors. It doesn't work that easily with particularly tax department, and it doesn't work that easy with workers' compensation. In terms of workplace health and safety, it's a new law that's come in. It's pretty far-reaching. Remember I told you about all those corporate veils we set up, with trusts, companies trading as something and trading as a trust, and they're the trustee and no one can get it, no one owns it, and it's all smoke and mirrors. Workers' compensation, there are no smoke and mirrors. The government says, I don't care what you call yourself or who you are, you look like the person who's conducting the business, you are the person responsible, and you are responsible. Not your corporation, not your trust, not your fancy legal deals. They actually come through and they grab the person, the manager, the person conducting the business or undertaking. There is no corporate veils when it comes to workplace health and safety. The law just reaches straight through all that stuff and grabs you by the throat. So 101, this is one we don't compromise on, yeah? You know how I've said to you before, the government is very generous towards small business in terms of just about everything you look at, there is a small business cop-out. This one they don't let you. This one is 100% compliance, guys. This is one where people in your workplace have to be there in a safe condition. So this is one we don't compromise on, and for the simple advice is that you personally are liable. Whatever you've got set up, you are personally the one that's going to go to jail if the government thinks you've done such a bad duty there. So I won't go into any more. You've got plenty to read there. If you're in business in Queensland, it's a Queensland-based law. If you're in business in Queensland and you do employ someone, you've got 5 days to register them with the workers' compensation to make sure that they're covered. These people may have their own ABN. They may pay their own tax. But remember, under workers' compensation, it's very broad. You really should almost cover anyone that works for you, regardless of whether you're doing them as a contractor or what, The only person you wouldn't cover as a contractor is someone who actually has their own ABN cover. And you would ask for that, and you would ask for a certificate of currency. You can go online and actually check out whether they've got a certificate of currency, and then you don't have to cover them. Just about everyone else, you really should make sure that they're covered. So just how it works. It's worked on an estimation. What they do is they say at the start of the year, or if you haven't been in business, but say you were in business, they say, what's your estimated wages for the year? Remember, not including the directors' amounts, just employee wages. They look at that, they say, okay, you're going to pay $30,000 in wages, no problem. They look that up against the type of industry you're in. If you're in banking, it's not very high. They hit themselves with a pen every now and again, don't they? And they prick themselves. Or paper cuts are pretty hard. But if you're painting the top of the story bridge, you know your premiums are going to be pretty high. So depending on the type of industry, they apply a percentage from 0.01% right up to 10% if it's the type of industry. They work that out and then they say, well, you owe us this amount. And being good cash flow people that we are, we ask for, can we get it in installments? And they say, yeah, sure, no problem. And so you can pay it in installments rather than having it to pay it all up front. So by the 31st, you've got to make your wage declarations. Remember, this is financial year, so it starts in 1st of July. You can pay your full premium by September, or you can ask to pay it monthly or quarterly, which is a smart way to go because you don't want to be paying out all that money if you can help it. There is such a thing as a certificate of currency, and you can actually type it into Google, but you go onto the WorkCover website, type in the number, and the certificate of currency comes up. And you should ask anyone that comes to work for you, you know, even your contractors, you should say, can I look at your certificate of currency? Because if they aren't covered, it's highly probable that you have to pay their workers' compensation. That's how the law works. The law is very, very generous to the workers, and it just expects anyone that's employing them or engaging them to cover them for workers' compensation. So this is why I sort of spend a bit of time on this, because this is one area we don't compromise. We must make sure that we've got, if we employ anyone, that we make sure that they're covered with workers' compensation. If you put on new workers, you can ring them up and say, look, I put on new workers. I think they'll, between now and June next year, they're going to earn $50,000. They will add that and adjust your premium. So that's what you need to be doing. Okay, there are some basic, we're now down to 10 basic things that anyone that you employ in Australia, they've tried to make it, the last Labor government tried to make this a little bit as fair as possible, and they're now down to sort of 10 things that every employee is entitled to. And that's the list, and looks like a good knowledge test for next week, isn't it? 38 hours a week, yeah. That's what you work, Gus? No. So I do that in a day sometimes, is that right? There's some employee obligations you've got to do. One is obviously keep accurate records if you do staff. I do pay staff. You've actually got to keep these records for 7 years. So it's pretty onerous, you know, what you've got to do with employees. There's pay slip things. You've got to be able to give them pay slips and detail what you've got to do. Nothing. You can read all the rest of that. It's one of the problems with employee records is that unions can come onto your property and ask to have a look at those records if they've got a right of entry. I think that's still in existence. I don't think the current government has stamped that on the head at all. So they can come in and sort of have a look at that sort of stuff. So, all right. So that's staff. I think the important thing with staff is workers' compensation, guys, and treating it very, very seriously. Don't treat it as something I'll get back to when I can. That's something 101. You just deal with that. You don't compromise on that. Privacy law. The government has this law that deals with any private information that you collect, and most of us are going to want to collect private information because we want customers' names, addresses, you know, home addresses if we can, and email addresses. We are going to be collecting a lot of personal information. You have a responsibility to make sure that that information is not shared. You just can't, you know, have that information. Banks are pretty severe on it, aren't they? These are principles, not laws. You know, it'd be easier if it was very prescriptive. If they said you must do this, and you must. They actually don't say that. They say here's some general principles to follow, and if you go against those principles, we'll sue you. But they actually don't actually say specifically what it is you've got to do. But most of them deal with just being sensible about people's information. You know, don't make it easy available. Don't just have it. Don't send it out there. When you send emails, don't put everyone in there too. You know, put them into BCC. You know, when you spam everyone, don't go sending everyone else's emails. That's not really smart. I hope you know about that. Oh, okay. If you're going to email a whole lot of people, you actually send the two to yourself, and then in the BCC, which is, what does it mean? Blank carbon copy. There you go. In the blank carbon copy, you put everyone else, because then when someone gets it, they can't see everyone else's email address. If you put it in the CC or in the two, then when you send someone an email, they get everyone else's, and so you've actually really given away that information to other people, and that's not really the principle of this law. The law is meant to protect people's privacy, and that goes to things like emails. There's two things that we have to be really, really careful of. One is if you have an employee and you get that tax file declaration, so most of you would have filled out one of those, is that right? The government's really strict about that one. That one's sort of a criminal offence. You know, remember I said about civil and criminal offence? Your mistreatment of that form can constitute a criminal offence under the government. So that, of all the documents that you keep, when someone fills out that tax declaration form, that should go in some vault somewhere because, you know, that's not just an everyday piece of information. That's something that the government treats very seriously because on there is a lot of that person's private details and could end up, you know, harming that person a lot if it got out there. So when you collect one of those, that tax file declaration, and even a person's tax file, those things the government treats extremely carefully, you know. So if ever you're in you get possession of someone's tax file, or particularly that tax file declaration sheet, please treat it with utmost care. Also, any sensitive information on health or people's medical, you've actually got to be very strict about protecting that as well. They're just the two things we've got to be really hypersensitive about. So what do we have here? So just with the tax file, people don't have to provide a tax file number, but if they don't, remember we take 46.5% of their income and send it to Canberra. Once you explain that to most people, they say, I'll give it to you. I'll sign it. So one of these things that the government doesn't says it's not whatever that word is. You're not obliged to do it, but if you don't, the penalty is quite severe. Yeah, so the criminal offence is the sharing of that information. If you passed that declaration on to someone else, it's a criminal offence. This is not civil. This is the police come and arrest you. So treat that document, if ever you're in the possession of that document, treat it with utmost care. Okay, a couple of things with IP. IP, intellectual property. We've already covered one of the intellectual properties or discussed it, which is trademarks, but there's also copyrights, and yeah, TM, I think I've told you about trademarks, haven't I? The TM. The TM is actually not a trademark. The registered is, and the C is copyright. These are just creations of the mind, and Cadbury's recently got their purple. You know, they protected that. Coca-Cola's have protected the dynamic ribbon. You know, you can't actually replicate that ribbon because that's actually a trademark. There's lots of things that can be protected. What we try and do is protect the actual name if we can, not the visual. We try and actually get to ownership of the name because the name is all powerful. So that stops someone using that actual name rather than just using a shape. Let's run through them. So IP law is not every country in the world. There are some countries in the world that don't acknowledge IP. Most of them do because they want to protect their own IP, obviously. So, but it's not global, and there are parts of the world that they will just take your stuff, rip it off, and produce it there because it's not recognised. They're all the things. So copyright is usually to do with manuscripts, and you get you can protect your work against copyright, I think, by just actually putting the little C. As soon as you produce anything, you just put the little C. You are the self-declarer of copyright. The only trouble is if someone knocks it off, you actually got to go and prove to the judge that you were the first one to produce that. There are really clever, and I quite like this, and perhaps I have never used it, but I've seen it in operation, where an organisation sends you a pouch, and the pouch is tamper-proof. One of those money things that if you tamper it, it all goes purple and doesn't work. So you get a tamper-proof pack. You put your original manuscript in there, and you seal it up, and then you post it to yourself. So it goes through the post, and when it's posted to yourself, they put the date stamp on it, don't they? And then when it comes to you, don't open it. Because that is proof that on that date, this is the original manuscript. Someone later on knocks you off, you say, listen, I'll take you to court. This is pretty powerful evidence that on this date, according to the Australian Post Office, you had this original manuscript, and the guy that's ripped you off, the earliest date he can come up with is after this date. So you win the case. So that's a clever thing. It's not expensive. Those satchels aren't expensive. So if you are writing manuscript, if you're writing something you think, oh, really, that was fantastic, I need to protect that, that's a really clever way of doing it. But you actually self-copyright. You just put the copyright symbol. Should have asked my sister that. You just put your name, copyright symbol, and the date, 2014, and that's copyrighted. That's you. It's just defending it is a lot harder, and that's why I say those satchels are quite good. But you can get it for trademarks, patents. That's something very new. My guess is that if you've got something that's really clever and you want to get a patent for it, probably about 250,000 is about the ballpark of what you're looking for. So it's an expensive exercise. Design patents are a lot cheaper. They're less, they're not as powerful, but they're cute. If you're wanting to sort of give your invention a little bit of, a certified number, sometimes a design patent. That just protects the design. There's none of the moving parts or anything, and the design can be a T-shirt. The design can be a mug or whatever you've done. If it's an original design, you can actually get a design patent. A lot cheaper. You're not talking about 250,000, probably talking less than 1,000 to get a design patent. And it's not a lot of protection, but it's sort of cute if you're putting together a VC presentation and you say we have the design patent for this. Makes it sound good. Plant varieties, circuit layouts. The biggest problem with IP is that you do get rights, but the government doesn't help you defend those rights. You have to defend those rights. So it's a bit of a problem, isn't it? So it's all very well to say, we'll sue you. Well, you go and try and sue someone for less than $50,000. It's about that amount. So trademarks give you exclusive right. And for us, it's only within Australia. So someone in New Zealand, unless Australia has a deal with it. But certainly the trademark is only within Australia's jurisdiction. There are some restrictions. So if you guys are thinking of doing Anzac, Olympic logos and Scouts, and anything royal, don't go giving yourself Royal Cafe or something because you can't do it. It can be a smell, colour, shape, whatever. There is an international protocol. There's full of spams in this game. We've got it every time. You get them all the time. As soon as you get a trademark, someone sends you and says, we've published you in all these places, now send us $1,000. And really it's just a scam. They're not gonna protect you at all. You can protect your trademark across 76 countries. Costs a lot of money. You got to weigh up the worth of it. Is that for you or is that for the person you sell it to the business to? Maybe they'll run and do that. It's an expensive exercise, and really your business is probably only going to be Australia-wide, so that's all you need to worry about. It's a 10-year protection, so when you apply for it, someone did trademark recently. Well, how much did what was your application? $100 or something? 60? 200. Is that 2 classes? No, just 1 class. Okay. I think it's probably 500 once you get it. It's a couple of $100 on application, and then if it gets approved, which can take 12 months, it's another $300 after that. So you're probably looking at $500 or even $800. $600. Probably looking at about $600 to actually finally get that. Once you've got that trademark, though, you've got it for 10 years. Like I say, the TM is worthless. It's certainly worth using. I would certainly use TM on all my trademarks before I've got them. But then after that, you're looking for the R. The R is the real trademark. You can't put R on your logo unless it genuinely is registered. Think about in your logo design where the R is going to go. Because the last thing you want to do is, because it's part of the visual effect. Part of that visual is where does the R go. And most of them put it as a full stop or as a sort of just at the top right is where most people put their R. But think about where that's going to be right at the start. And so I suggest you put the TM there in the early days and then replace it with an R once you've got genuine covered. That's our first logo. Pretty cute. 1905. Hot. Das? No. I didn't think it was much either. Oh, there's classes or categories. There's about 45 classes that you can register. So someone can actually register your name in another class. the classes are so different that, I mean, I had Kraft, no, what did I have? Earls as a sandwich shop, and someone had mufflers, Earls mufflers. And obviously they were never going to be competing in the same market, you know, unless I opened Earl's Cafe alongside his muffler shop, and that was going to be confusing. But so there's different classes, so you've got to think about the classes, and there's service classes and there's product classes. Mostly you would go with both, one from each. You would go from the business that sells it, you'd protect that trademark, and you'd protect product. In other words, the products have got that brand on it. So normally you would go with two. So you could have it for a cafe, but you might also have it for the products that the cafe sells with that brand on it. So you might actually go with two. So think about that. Don't go for any more classes than that unless you really think you're onto something hot. But you know, maybe you do one class for sure, two classes, and just remember someone else can own some of the other classes. So have a check and make sure that whether you want to protect your idea or your trademark, make sure you've covered all the classes that you need to cover. Patents, yeah, that clothes hoists, yeah, remember swinging on them? No, I did. We had 6 kids, you know, 1 on each corner and 2 pushing. It was pretty good. It was like a weeping willow when it was finished. It wasn't really a clothesline. But Cockley, hey? Oh yeah, they gave up. They gave up in the end. You know, Mum ran out of thongs. Yeah, she just couldn't. Cochlear ear implant is obviously a patent that we have. This give you a right for 20 years to commercially exploit an idea. It's great. Inventions are great. They just are. First of all, they've got to be absolutely new. The second thing, you've got to tell the world about it. But you can't tell the world about it until it's been approved. If you release your brilliant idea before you've got approval, it's actually called public domain and you can't patent it. So you have to be incredibly secretive about it, and you've got to be secretive about it for a long time. It can't get out. If it gets out, it's called public domain, and therefore you can't trademark it. You can't protect it. So it's this big cloak and dagger thing. And then finally, when you do get approval, guess what you do? You tell the world how to make it. And there's 14 countries in the world that don't apply by the thing, so they start manufacturing it. They say, what a great idea, Damien, let's start making them. So you've got to question whether that's a smart way to go, you know. You've got to, you know, maybe it's people with deep pockets or someone with an incredible invention to do so. Anyway, it's there. Design patent is a lot cheaper. It still looks fancy. Look at that. Design patent. Sometimes these are really good. It's just to deal with a unique visual appearance, that's all. You've just got to prove that it's got a unique visual appearance, and you get it's cheaper, it's less protection, but sometimes it's it's one of those things that is nice to have, you know. Particularly if if you took your cosmetics and you changed them into some sort of design case or whatever, you might think about doing that. They are very valuable in a sale when you say, you know, we have a design patent for that, you know, because buyers, you know, that's that subjective margins that they're buying in your business. Wow, we're getting design patent. They probably don't even know that it's not a proper patent, it's just a design patent. In other words, a look and feel patent. A couple of things with Australian consumer law, and I think this is my last section. We just have to be very careful about how we do business. The government in Australia have really got onto it. The Australian Securities Investment Commission and the Competition Commission have both joined forces to really come down hard on the way we do business with consumers, how businesses do business with consumers. And they've got like 5 books, 5 books that you have to read about how to do things. You know, but when you summarize them up, if you are offering genuine value, and most of you guys, or all of you guys have come up with ideas that offer genuine value, and you do it in a commercial way, in other words, where you're building long-term relationships with customers, none of you will run foul of this sort of stuff, except if you're not aware of it. Because these laws are really there for those people that are deliberately going in to rip off people and get out of the market, which I know that's not our guys. We just have to be careful about misleading and deceptive conduct. We talked about bait advertising, and we used to do it at David Jones. That was our mode of operation. We would get a fridge, we'd buy 3 of them, we'd sell them at half the cost price. That would have people pouring up the escalators, and then on either side we'd have fridges that we could make profit out of that were $100 more or $50 more, And when they come up, they'd come all the way from Caboolture, run up the escalators, and we sold the first 3, and they're disappointed, and they've made all this thing, and our salespeople were clever enough to move them across into the other products that we made money out of. That's called paid advertising. It used to be David Jones' basic marketing ploy back in 1970 when we used to do stuff. So that's illegal now. You can't do that anymore. And the government forces a lot of these places like Aldi and that to carry significant stock to last at least until a certain time. And mostly it's until probably 3 or 4 in the afternoon, and then it's okay. If they sell out too early, the government can actually say that was paid advertising. You've got to go and buy a whole lot more. So they have to be very careful about how they do that. So that's an important thing there. So you can't sort of play this small print, but you didn't read the small print. Guess what? Whether it's in small print or whatever, you know, it doesn't protect you. By saying it's in small print, if you genuinely misled someone and they've got it, then they've got it basically a case against you. Even if it's likely to mislead, that's one of the problems. And you can mislead by not saying anything too. So it's pretty. Look, if you're honest with your if you really see your customers as a long-term value that you want to make money out of a long period of time, you won't run foul of these things. But these are just things you've got to be careful of. This is an interesting this unconscionable conduct that in business, and this is interesting. It's not just unconscionable conduct with customers. This one is important to us because it's business to business. If a bigger business in your market comes out and plays dirty, half-price stuff, opens outside of your business and just wipes you out simply because they're big and powerful, that's unconscionable conduct. And so the government protects small business against big business. You know, the fruiterer can exist outside of David Jones or outside of Woolworths because Woolworths can't use its market power to crush them. If they did, they could be accused of this unconscionable conduct. So basically, it's an interesting thing because it doesn't protect us. You know, because we're the small guys in this game. If someone is using unconscionable, in other words, they're using their market power to crush you, it's actually against the law now. You would think.
Don't they do that?
They try to. They try to. But you know, they run on. They run that. You know, they've got to be careful.
Yeah.
You know, their lawyers are obviously telling them what to do. I think this guy had fridge and freezer seals. Why he's up there is he had a central number that everyone would ring, and then he would farm it out to all the guys. And then one day he decided to just charge 50% more than he used to for doing that for the franchisees. And the trouble is he had the central number. You know, and so they said that that's unconscionable because the guys had no understanding when they signed up that the thing was going to go up by 50% in one fell swoop. You know, so he actually got caught doing that as a. You know, you would think, oh, he's just making money. Well, in Australia, we've got a way of making money, and once it gets to an unconscionable level, actually the government steps in. So it's interesting. I mean, it's like I say, in America, there wouldn't be no such thing as that, would there? You know, but in Australia, we have that sort of approach. It's unusual. Country of origin, be careful about how if you're bringing stuff in from overseas, be careful about how you use made in Australia. There's the made in and a product of. If it's a product of Australia, it's got to be 100% made here. If it's made in, it has to be at least 50% transformed. So you can bring stuff in and then transform, like in terms of cost. If you add an extra 50% to the cost in Australia, then it can be made in. But you can't bring something in and put it in an Australian packet and say, well, it's made in Australia because I put it in an Australian packet. You know, it's not going to make it. So just be careful about your use of those words. Some of these things you can't use, obviously they're and then you can't mislead people. You can't buy it from Italy and then hang Australian symbols off it, you know.
Can you put Australian owned?
I think that's okay.
You have to register with these?
You don't have to. No, you don't have to. It might help you, but it's not a must. That's what they're trying to do, is get you to register with them, and then you can use their symbol. Just got to be very careful about, before you call something made in or a product of, just go and check the act. There's 5 books that are pretty easy to read, you know, if you're interested in it. We're not going to do it in the course, but there's 5 books on this, and they've done a pretty good job on just showing you what you can and you can't do. There's some information standards. Look at what they've done to cigarettes. I think they're a set of tonsils that aren't looking real good. Information standards really deal with labelling of cosmetics, what goes into cosmetics. In Australia at the moment, tobacco. If you're doing anything with tobacco, you have to do it. And anything to do with clothing. You've got to, if any of you are planning to do something with clothing, you've got to think about the care instructions. That has to go on everything you sell, and I think you have to have the country of origin as well, and that sort of stuff. So there's this whole set of laws. We have to be conscious of it, and we have to be watchful of it. But you know, like I say, as long as you guys are following, if your attitude is to build long-term customers, you shouldn't fall too much foul of those sort of things. Okay, well, there's a lot of easy questions in there for next week, isn't there?